Everybody to this public hearing of an appeal from this board granting of a conditional use permit to Susan Smith to operate an animal sales and swap meet at 2355, 2357 K Road. And we're hearing this under the provisions in our ordinance of section 1116A3, which I will not read. Do we have a roll call?
Hang on just a second.
That's it.
Scott Baldwin.
Here.
Margaret Costa.
Here.
Nancy Burkhart.
Here.
Rick Ferris.
Here.
Daryl Henderson.
Board, as you may know, we don't have a copy of the minutes of our, I believe it was July 12th meeting, because they're out being prepared in the way those things are prepared for legal use. So bear that in mind as we go through this. What we're, just as a reminder to everybody, the hearing, the subject of the hearing is this conditional use permit, which was granted on the 12th day of July 2021. And just for purposes of refreshing everybody's memory, I'm going to read the conditions to it. And of course it was to Susan Smith on K Road, which I cited. The conditions were initial approval for July 13th to October 31st, 2021, and it requires a new application upon term conclusion. The event is authorized to be held the third Saturday of each month during the approved operating period from 8 a.m. to 4 p.m. Must adhere to the operations plan submitted. Must adhere to all relevant health and safety laws. Must file an emergency action plan with the local emergency services. No camping is permitted. No amplified music is permitted. And all board members, you have a copy in your little folders there. No amplified music permitted. Use of fireworks is not permitted. Alcohol consumption shall not be permitted. No firearms authorized as declared by the applicant. Permitted as an animal swap meet only per section 7.00 official schedule of district regulations, category 829 of the city of Madison zoning ordinance, with no other use permitted. And conditional use may be revoked and or final. I won't read that part. And the understanding on another letter here, which is from Joe Patterson, the associate planner, this one here, which I believe board members are in your little packets. It was a summary of permitted categories, but the paragraph I will read as a refreshing our memories. The following are authorized under the conditional use permit, category 829, other agriculture related activities for the farm at 2355 North K Road. Zone residential agriculture per discussion and granted by the City of Madison Board of Zoning Appeals during the July 12th, 2021 regular meeting. That includes number 1, animal swap and sales. Number 2, a petting zoo. Number 3, bounce house type of activities for children. And number 4, food items or food trucks to include all items except alcoholic beverages. No other use is authorized under the conditional use permit. So that's what the hearing is about. These two documents. So the first question I'm going to ask you board members, do you feel strongly enough that you're prepared, that you're knowledgeable about everything, you've had all the necessary information or whatnot, that we can go on? Or would you prefer to continue or table this to say our next regular meeting in September, which I believe is September 13th, correct? What's your your feeling, board members? And of course, our attorney, feel free to.
I would recommend to go ahead and hear from the attorneys that are here, and if we get to the end and there's some questions, and we could address that consideration then too.
Okay. Is everybody in agreement?
Yes.
Okay. Well, then on we go. Now, we're gonna have some rules in this meeting. First, I understand both Goalies and Smiths have attorneys. The lawyer for Mr. Goalie will give you 15 minutes to present your case, followed by the lawyer for Ms. Smith, 15 minutes likewise. Then Mr. Goalie's lawyer will give you 5 minutes to rebut anything you wish to. And Ms. Smith's lawyer will give you likewise 5 minutes to answer or whatever. And we may have a small time for people in the audiences for both Mr. Goalie and Ms. Smith, which I would ask that you limit yourself, if we do this, to 3 minutes, very short. And if someone from the audience speaks, I'd ask you to bring up not things that we've had in previous hearings, but anything new you may have to add. So, and I have asked Mr. Patterson to keep time. So, we will proceed. Mr. Lawyer for Mr. Goalie, would you come up and introduce yourself? And you have 15 minutes.
Good evening, folks. My name is Zach Van Vector. I'm an attorney with the law firm Stites & Harbison. I'm here today representing Mr. Goalie. Thank you for the opportunity to be heard tonight. We appreciate it. At this point, the board should have received Mr. Goalie's appeal dated July 29, as well as my supplemental letter of August 1st, through which we provided the board a preliminary outline of the grounds and the issues on which this appeal is based. I plan to focus my comments tonight on the legal aspects of this appeal, and because I appreciate your time, I will endeavor to keep those comments as succinct as I can, and hopefully well below the 15 minutes you've allotted me. I believe Mr. Goalie would like to address the board as well once I've finished. First and foremost, I'd like to address the fact that the applicants proceeded with hosting a swap meet event this past Saturday, August 21st. Where an appeal has been filed such as this, Section 11.32 of the ordinance imposes an automatic stay on the action being appealed unless the building inspector certifies that a stay would cause imminent peril to life and property. To my knowledge, no such certification has or was or has been made. I actually sent a letter last week to applicant's counsel, copies of which were provided to the city attorney and to the building inspector to put them on notice of that automatic stay provision. The language of Section 11.32 is form zoning language. It appears in any number of ordinances around the country. And courts have interpreted that language just as we're suggesting here. For example, imposing an automatic stay on construction or on further renovations while a building permit was on appeal. I would remind the board that when previously granted the conditional use permit that's at issue, in several instances, members of this board reiterated to the applicants that the rules must be followed as stated in the ordinance. Yet despite that, and despite having been put on notice of the automatic stay provision, the applicants proceeded to hold a swap meet this last weekend, and by doing so, they directly violated Section 11.32 of the ordinance. For that reason alone, the BZA would be well within its authority to revoke the conditional use permit. Turning more to the substance of our appeal. Respectfully, the BZA erred in granting this conditional use permit because the proposed uses are, in fact, not permitted under the ordinance. Section 11.73 provides for the general standards that are applicable to all conditional uses. The very first item under that section requires that the use at the proposed location is, in fact, a conditional use as established on the official schedule of district regulations adopted by Section 7 for the zoning district involved. The BZA seemingly determined that the proposed use of having an animal swap meet fell under category 829, other agricultural related activities in section 7. And the BZA further apparently concluded that allowing food vendors also fell under category 829. The conclusion that those uses were conditionally permitted under category 829 was respectfully erroneous. Regarding the animal swap, first, the mere fact that animals are involved does not make this an other agricultural related activity, nor does the fact that we happen to be in a residential agricultural district. It's important here to look at the use that is actually being proposed. We're not talking about a farming operation that wants to sell livestock or poultry or any other animals that it raises. Rather, what we have here are third-party vendors bringing animals onto this property to sell them to consumers. Just a few years ago in 2018, the Indiana Court of Appeals reiterated, quote, Indiana has long held that animals are personal property. And for reference, that's the Little case, 107 Northeast 3rd, 478. It follows from that the sale of an animal to a consumer, just like the sale of any other personal property, is a retail transaction. Section 7 of the ordinance lists 45, that I counted, separate categories for retail activities. Not a single one of those 45 categories is either a permitted or a conditional use in a residential agriculture district. Rather, each and every conceivable type of retail activity that's envisioned by the ordinance is expressly prohibited in an RA zone. While there's no specific retail category for the sale of animals, there is a category for retail other trade at number 599. There also are categories such as numbers 816 and 817 for farms that raise livestock and poultry. But again, those are inapplicable here where the proposed use is plainly the selling of personal property to the public. Quite simply, category 829, other agricultural related activities, cannot properly be used as a catch-all to allow for a conditional use where that use would correctly fall under another, more specific category of use that is expressly prohibited in an RA district. On that point, Indiana zoning law is clear that, quote, where an ordinance specifically lists a use in one category but not another, that use will be assumed a permitted use only in the category where it is mentioned. And that's the Brandmeier case from 714 Northeast 2nd, 179. The bottom line, folks, is this. If the city wanted to allow for the retail sale of animals in an RA district, it could have done so by making that a permitted or a conditional use. Instead, it decided that all retail activities were permitted, or were prohibited rather, in a residential agricultural district. Consequently, the BZA erred in finding that the proposed use for an animal swap meet was permissible as a conditional use under category 829. As for the aspect of food vendors, similarly, the board incorrectly concluded that food trucks or food vendors were allowed as an other agricultural related activity under category 829. Again, what we're talking about is third-party vendors coming onto the property to sell ready-made food items. The applicant's advertisement for the event that was held last weekend says there will be, quote, food vendors / baked goods. This again is necessarily a retail activity that would fall under one of several other categories, such as category 544 for confectionaries, 546 for baked goods or bakeries, or 549 for retail other food trade. All of which, again, are prohibited as conditional uses in an RA district. So again, the fact that the ordinance specifically allows these types of activities in certain zoning districts but not others necessarily precludes the use of category 829 as a catch-all to allow for what is otherwise a prohibited use. Because neither the retail sale of animals nor the retail sale of food items is even eligible as a conditional use, the BZA could not correctly find that such proposed uses satisfy section 11.73 subsection 1. And for that reason, the BZA should summarily reverse its decision to grant the conditional use permit at issue here. Now, even beyond the application of category 829, the BZA also erred in several ways in addressing the traffic issues that were raised relative to these proposed swap meets. Section 11.73 of the ordinance requires the BZA to consider, among other things, whether the proposed use would be hazardous or disturbing to existing neighboring uses, whether the use would be adequately served by public facilities, including public roadways, whether the use would be detrimental to any persons or property by reasons of excess traffic, and whether the use would be designed not to create an interference with traffic on the surrounding roadways. Section 5.36 of the ordinance further requires the board to conduct a traffic impact analysis in any instance where the surrounding road system may be overburdened. To my knowledge, no such traffic impact analysis was conducted before the conditional use permit was granted. But what the board did hear previously was substantial testimony from a number of neighboring landowners about the character of the roads here, the volume of people and of cars that would be coming and going, and the detrimental impact of the excessive traffic resulting from these swap meet events. Respectfully, I believe the board was unfairly discounted those concerns. To the extent the board was relying on the White Barn case that went up to the Court of Appeals a few years back, I would submit to the board and to the city attorney that any reliance on that case was misplaced for at least two reasons. First, the White Barn decision is designated as unpublished, and as such, it has no precedential value and should be afforded no weight here. Second, insofar as that White Barn decision seemingly concluded that there had to be proof of accidents to establish an increase in traffic, I would submit to you that that conclusion itself was erroneous. It's notable that the court did not point to any actual authority or legal precedent whatsoever to support that statement. And it simply defies common sense that a detrimental increase to traffic could not exist unless there have been accidents. This board is in the proper position to evaluate the factors that are set forth in section 11.73 as they relate to these traffic issues. And again, the board heard substantial testimony about how the applicant's proposed use would create traffic and roadway issues that should have prevented that proposed use from satisfying the elements of section 11.73. The fact that no traffic impact analysis was conducted, particularly in the face of that testimony about the traffic and roadway issues, warrants the reevaluation and reversal of the board's prior decision to grant this conditional use permit. To conclude, I would urge the board not to forget the fact that the conditional use permit application at issue here came after these applicants had, for however long, already been conducting these unlawful, unpermitted events. And after the city was forced to take legal action against them just 3 months ago by filing a complaint in Jefferson Circuit Court and a motion for injunctive relief asking that court to permanently enjoin them from conducting the precise activity that is at issue here. I said I'd try to be brief, and I hope I have been. With that, we would respectfully ask that the BZA reverse its decision to grant this conditional use permit under its authority to do so pursuant to section 11.76 of the ordinance. Thank you again.
Very good, thank you. I think we will just proceed to Ms. Lawyer. Come on up, introduce yourself,
Thank you.
and you have 15 minutes.
All right, thank you. I appreciate the opportunity to be here. My name is Michael Gillenwater, 411 Watt Street, Jeffersonville, Indiana. And I appreciate the opportunity to be back with you today after being here in July. At the risk of sounding like I'm pandering to you, and I'm really not, I think that this board was as thorough that night as any board I have seen, any board of zoning appeals, in addressing the issues and listening to the testimony and making findings, polling its members on many things. So I appreciate that. And while I respect Mr. Van Vactor and his interpretation of what happened here, I was here for that section of the meeting that took over 2 hours. And I know that the board heard extensive testimony, not only about traffic, but about other things. And I appreciate that, but I'm not going to refute what he said because I know what you heard at that meeting. I'd like to point out a few principles, knowing that you are going to rely upon your lawyer for legal advice, as you should. But there are some things that I think we can all agree on. I lost my glasses, and I can't read without them anymore. One thing is that when an ordinance is subject to different interpretations, courts generally rely on the board or organization, administrative organization that's called upon to administer that ordinance to decide what it really means. It's a basic tenet of statutory interpretation which applies to ordinances too, that every word has meanings. And if there's something in the ordinance, you need to read it, and hopefully it is consistent with other things. You're supposed to read it in a way that it is. I think if I understand the argument, the basis of the main argument is that you can't rely upon this section, was it 829, that says other agricultural related activities. Now the question is, what does that mean? And it means, frankly, what you think it means, whatever you think it means. It means something. If there's any doubt about what it means, then the benefit of the doubt goes to the person being regulated, who's my client, because it's a basic tenet of statutory interpretation that since zoning ordinances are in derogation of common law, that they're strictly construed, and any benefit of the doubt goes to the person being regulated. That's just the way it is. So not only do you get to decide what that means, but you have to assign some meaning to that section. And it's very possible, and I believe likely, I've been in the municipal law business for a few years, and I've drawn up statute or ordinances. And sometimes the council or the commissioners or whoever it is that's enacting these things, or city council in this case, put that in there for a reason, and you have to decide what it means. This board has tremendous authority when it comes to what people can do with their properties. You can grant variances, you can do things, allow people to do things that are not strictly permitted by this ordinance. And it says here that you can decide what it means when it says other agricultural related activities. If you think this is an agricultural related activity, then it can happen. Now, I noticed that, the term retail is not defined by your ordinance. So what does retail mean? It means whatever you think it means. And if you think that this is an appropriate use, you can put that in there. you can interpret it in that way. I'm not going to quote law cases to you and give you citations. You can rely upon your attorney to do that. I think that Mr. Van Vactor and I may agree about, we may disagree about some things, but I think we agree about a lot of things, and these principles of statutory interpretation, I don't think he would dispute, because they come out of the very cases that he cited to you in the paperwork or the letter that he sent. That's where I got some of these, some of this language. So, you know, what I'm going to ask you people to do on this board is to, you know, remember what happened in July. And you did consider the traffic, you did consider the effect on the neighborhood. There was no evidence presented about, you know, accidents or other problems. And so I would ask you to just affirm what you have done. If there is any question, if they want to appeal this to the courts, they can. But the courts are going to give great deference to what you decide to do. The courts will not substitute their opinions for yours when it comes to this statutory interpretation, or this interpretation of the ordinance. I think that you did what was right. I think you did what was within your power. Again, ask your attorney, not me, and he'll give you his opinion about that. But I would encourage you to leave the order in place, and if they want to appeal that to the courts, they can, but I don't think that they will have much success. Thank you.
Well, at this time, Mr. Goley's lawyer, Mr. Van Vactor, come up, have 5 minutes to rebut and make any comments you wish.
I'll be very brief. When we're talking about what qualifies as other agriculture-related activities, there are plenty of activities that would fit that definition. And they're all related to agriculture. Third parties coming onto a property and selling animals that aren't raised there to consumers has nothing to do with agriculture. That could happen anywhere. The only connection to agriculture here is the fact that we're in an RA district. Third-party food vendors coming onto a property and selling food has absolutely nothing to do with agriculture. Mr. Gillenwater suggested that retail means whatever you think it means. Well, folks, retail is hardly an ambiguous term. Retail means the selling of goods to an end consumer. That's exactly what we have here with third parties coming onto the property and selling animals that they bring onto the property to the general public. And with food vendors coming onto the property and selling food items to the general public. It's unavoidable that that qualifies as retail under any definition you can find. And believe me, I spent some time today looking into some of this, and you can look at the Indiana tax code, you can look in the dictionary, it all leads to the same conclusion. What I would leave you with is to consider the practical effect of this, and I believe this was commented on by one of the board members at the last hearing. The practical effect of allowing category 829 to encompass what they're proposing to do here would effectively open the door to allow anything to fit in category 829. That can't be what the city intended when it drafted the ordinance. It can't be that the city intended, if there's a use that is prohibited, it's not even available as a conditional use. It's prohibited in this district. It cannot be the city's intention that you can use a catch-all category like 829 to shoehorn in what is otherwise an outright prohibited activity. Thank you again.
Mr. Gillenwater.
Thank you.
5 minutes.
If a farmer raises grain and he sells it, then according to Mr. Van Vactor, he's violated the ordinance. If he raises apples and he sells them, if he raises hay and sells it, if he raises cattle and he sells the milk, he's engaged in retail activity and he can't do it in this district. I disagree with that. It doesn't make any sense. If retail is strictly prohibited, then the farmers can't operate farms in this district due to zoning classification. That doesn't make sense, and that's not what it means. It's not what I think it means anyway, but again, what you think matters a lot more than what I think. I don't think I need to address anything. I don't want to repeat myself, so I'll just leave it at that.
Thank you. I think we have some time for from the audience. First, we'll have from Mr. Goley's side. We'd be glad to give you 3 minutes to make your points, preferably some new point that hadn't been made before. So, Mr. Goley, if you'd like to speak, come on up.
Hello, Jason Goley, 1962 East Armand Lane, Madison. I have some information to share with you, if I may. There are 4 copies of these and only 1 copy of these. I think it'd be a little easier for you to understand and visualize what I'm trying to lay out with the map. That's about traffic. I'll do my best not to double back on anything that's been covered already. So on August 21st, last Saturday, I counted approximately 260 vehicles at the end of my driveway going down the road between 7:30 and 3 p.m. That was only the vehicles headed towards the swap meet, and 5 of those were between 7:30 and 8 a.m. that clearly had animal containers either behind them or in them. I would estimate somewhere around 200 people were on site at any given time on Saturday, and I did observe 1 vehicle parked at the end of my driveway, blocking my driveway during this time period. So there's been discussion about traffic and what that impact is. It's hard to go backwards when we were prohibited from discussing that in the meetings in July and talking about traffic. So this is a real event that was captured with pictures in my driveway, blocking my driveway. And it was several minutes, long enough for me to walk to the house and go talk to them and ask them what they needed and tell me they were waiting on their spouse and pointing towards the Smith property. The next thing I wanted to talk about was the map, the traffic impact analysis. I think there is some data out there that at least starts the discussion. So according to Ndot, between Old 62 and 421, that road saw 669 vehicles in a 24-hour period. Between Highway 62 and Crossroads, that saw 1,411 vehicles in a 24-hour period. So if we use the baseline of 2,000 vehicles, and bear in mind, Old 62 is definitely the primary attribute to K Road, but K Road is not the final destination for a lot of the vehicles on Old 62. So if you assume the full amount's going to K Road, which they're very clearly not, and we have 260 vehicles going to the swap meet, that's only half, because that's only one direction. So you're looking at 500 and some odd vehicles going to this swap meet. That's a pretty big percentage of 2,100 vehicles on Old 62. I think that warrants a traffic impact analysis. I think these are a significant burden, and I think the BZA does have to address these, obligated to address these traffic concerns. I won't reread my letter to you, but I wanted to talk about the 829 use as well. Just an example on that, if I have cattle and I want to sell leather products from those cattle, I do believe I'd be able to do that under the agricultural umbrella as a roadside stand or whatever it may be on my farm. But if I invite 1,000 other people into my farm to sell belts, jackets, shoes, whatever processed leather products, I think that'd be a pretty clear distinction that that's no longer an agricultural product. The same thing that applies with any other agriculture. It is most oftentimes processed to some extent before it's sold. And as a farmer, I sure wish I could get retail prices, but 9 times out of 10 I get wholesale prices. So, but most agricultural commodities have to have some processing. So as stated earlier, anything could be considered agriculture when you look at it that way.
And it remains.
Excuse me, was there a question?
1 minute remains.
Okay.
Chairman.
We talked about the baked goods, and I guess I just really question if this was a standalone item. I don't see how it would be approved between the baked goods and the hot food and hamburgers and lunch food. So why was it allowed to be sold under agriculture? And what conditions are there that prevent that from being the primary use here? Because in the July meetings and all this discussions, I haven't heard any percentage breakdown of what the food's gonna be and how that could potentially be the major draw. We don't know. I don't think that's ever been shared, at least not publicly. So I guess I have the perspective that there's a handful of issues here that are contradictory to the city zoning ordinance when the conditional use permit was granted. And the city needs to adjust their decision to align with your own ordinance as well as adjoining property owners' rights. So the pictures I put on there, most of those were from last Saturday's swap meet, outlining the food, where it was, the times, and just a few overall pictures of what happened there. As well as the pictures of the vehicles before 8 a.m. There were about 5 vehicles that came in between 7:30 and 8 a.m. down the road that were clearly with animal transport containers.
Jason, were those your only copies of those?
Which
Were
ones?
those your only copies of those?
The pictures? I can give you these, but they don't have all of them.
Okay, we'll make copies.
You can
again.
keep those, sorry.
Okay.
Yes,
We can
I don't
keep
have
those.
additional ones for the extra board members. You can keep those copies.
Sorry, I didn't ask that very well. Thank you.
Thanks.
Excuse me, sir. May I say something for the record?
Well,
Okay,
let's wait a minute.
okay.
Was Mr. Goley from his side speaking? I think if somebody else from the audience has anything new that wasn't brought up before, from Mr. Goley's side now, if you'd like to speak for 3 minutes, but just don't bring up the same stuff we've heard many, many times before. Okay, then from Ms. Smith's side, if somebody from the audience would like to speak on for her behalf, we'd be glad to give you 3 minutes likewise. Okay, you want to speak, ma'am? Fine.
My name's Nancy Kidd. I live at 2668 North K Road. Once again, I'm a redhead stepchild. I don't like to choose sides, but he brought up the traffic on Saturday. I know you asked us not to bring that up again as it was brought up at the last meeting. I too sat on our porch from 7, well before 7 actually, having my coffee until late in the afternoon. And there were really no traffic problems. We did have some stuff out that had a sign that said free for anybody. And there were some people that did pull over and pick it up. One of the other neighbors had some vegetables on a table with a sign that said free. A few people pulled over and picked it up. I will do that with our apples as well, because I have so many I can't put them up, preserve them or freeze them. But it was very quiet and peaceful. At 8:45, I actually posted on Facebook that at 8:45 it was very peaceful and quiet. The only noise was either a tractor or a backhoe or some sort of heavy equipment in the background. Living on the road, I've been there since, 88, 87. The traffic has increased when the hospital went out there on the hill. With the subdivision, we have seen an increase in traffic for years now, and it's not getting any less. And one day, like I said before, and I'm repeating myself, and I apologize for that, we know one day, and it's one day a month. We can schedule around that. We can be good with first-time neighbors, as long as they're following the rules and the expectations that you all set before them. I just wanted to bring that up because, we set 2. And had there been anything that happened that, didn't follow those rules, I did not go to the swap meet. Once again, I'm probably the only one in here with a mask. It's because of my job. I'm protecting you, not me. I'm not gonna go out in public. Been to the grocery store since March 10th. I do the click list to protect people. But I would love to go and see. I've not had that opportunity. The other thing I wanna say is, I only see it's Jason and I that live on the road. Oh, and Mr. Hay, correct?
Yes.
If there's anybody else that actually lives on K Road, I haven't met you. You haven't introduced yourself, and I've been there how many years? The other neighbors around them are not here. So I just wanna point that out too. They're not here to support or not support either of the people that are here today speaking. And, you know, that speaks volumes to me as well.
Excuse me, ma'am, could I get your name again? I missed it.
Nancy Kidd, that's Kidd,
Thank you.
which everybody should know by now because I'm getting, letters, certified letters with Lawson on it, and I haven't been a Lawson for many, many years. Thank you guys for your time.
Yes, sir, we can give you 3 minutes if you want to speak for Ms. Smith.
Well, I'm not speaking for Ms. Smith, but my name's Mark Goley, and I have also own a farm south of Jason Goley, who's my son, and I'm here, and which Ms., the previous speaker did not state, and there are several other people in this audience from the community, which, opinion of that by a huge majority is in favor of Mr. Jason Goley's side of this event. So there are more people here than what was just represented by the previous speaker. So I just want to make that statement. Thank you.
Just to verify, I said local neighbors, and you guys don't live out there, you just have the farm, you're not resident there.
Well,
Thank you.
that's true, but I'm a property owner there, and I'm actively engaged in a farm operation there. And I think that one thing that we're missing here, since that statement was made, I just think we need to represent all aspects in the zoning of this buffer area, which is residential and agriculture. And I don't believe we're representing adequately the agricultural option here. And the agricultural option of me, myself, and my son and others in the area deserves to be represented because this is zoned residential agriculture. It's not just zoned residential. So yes, I don't live there, but I actively farm there. And this is an obstruction to that, and for the reasons stated, because of the traffic and other items. So I think that's a legitimate concern that needs to be addressed, so appreciate it.
Well, I think, board members, we've heard both sides, we've heard rebuttals, we've heard some from people who live in the general area. I think it's time, board members, if you have questions and you'd like to direct it to one or the other of our attorneys, then I think this is the time.
I guess I have a question about when, I'm sorry, sir, I can't remember your name.
Zach?
When Zach, mentioned the stay, and should there have been a stay?
Excuse me, based on my reading of the ordinance, I don't think there should have been a stay. I think that section is based on a building inspector's decision on a building, procedure. I think the outline for appeals in this situation has been handled correctly.
Other board members? Do you have questions? Think it over here for a minute.
Yes, I do have some questions for Mrs. Smith. The testimony that we heard in the July meeting about the activities that were gonna take place included things such as, swapping poultry, for breeding purposes, swapping poultry for food consumption, and other animals. You know, nobody listed typical farm animals, cows, pigs.
We had cows and
Sheep.
pigs as well.
So, is there also, trade in vegetables? I mean, is anybody selling sweet corn, tomatoes,
The vendors did.
cucumbers? Okay. Okay, that's all I've got for now.
Any other questions, board members? Comments? Look over your notes.
Are we allowed to make comments?
Yeah, certainly.
Well, I've got some comments I'd like to make.
Unless there's a good legal reason we shouldn't, I'll direct that to our attorney.
Devin, am I allowed to make comments?
Oh, yeah, if you wanna make comments, you can.
So, the, part of the issue here is the definition and interpretation of the verbiage in our ordinances and board members' interpretation. So, I tried to do my homework and look at this subject at a deeper level. I looked up a report from the Indiana Department of Transportation called the Ndot Access Management Report dated September of 2009, trying to look for some guidance on what constitutes excessive traffic on rural roads. And there's a lot of information in this report. It's 168 pages. I didn't read all 168 pages. But there are some statements in there about, you know, the purpose of roads. And one of them is so that people can have access to their property and to use their property, you know, as they see fit. I didn't see any statistics on how many cars per hour, you know, was a reasonable amount. It did talk about the economic impact of traffic on the roads. And I've driven on K Road many times. I don't know that I've ever seen any work done on the road above and beyond what's done on any other county road. So, trying to define excessive traffic is a challenge. And I think there is room for interpretation there. The other thing I want to say is this activity that the applicant has applied for, although directly mentioned are animals, this seems to be a farmer's market. And the Indiana State Department of Agriculture defines farmers markets as a common use in an industry that most people don't even know about called agritourism. And other activities that are listed in this report list Christmas tree farms, corn mazes, pumpkin patches, farmers markets, U-pick operations, wineries and breweries. And this website lists agritourism and the zoning ordinances, if they're available, for every county in the state of Indiana. Now, I was disappointed because when I got to Jefferson County, it said, for more information, click here. I clicked there and it didn't take me anywhere. So I couldn't get more detail of what was published about the ordinances in Jefferson County. But I will tell you that there are several counties that have very detailed ordinances for these agritourism activities and give some, I think, very well thought out definition to the uses, and one of them is, and this is listed under our neighboring county, Bartholomew County. It says a farmer's market includes only those sales operations which occur in a pre-designated location and in which the vendors are the same entities which have raised the produce for sale. A farmer's market occurs off-site from the location where the products have been raised. So, as I think about the testimony in the July meeting, there were several people that talked about bringing animals that they raised to this location to sell, trade, or swap. Which fits in with the definition of a farmer's market. So, I didn't think I'd find much information about any of this, but I did. So, I wanted to present that.
Just for my understanding of your well-made comments, this thing is in effect sort of an agritourism or farmer's market.
Yep, the Indiana Department of Agriculture defines farmers markets as being in the agritourism industry.
And your other point is these agritourism type activities are found in virtually every county in Indiana.
Yep. Some counties had very detailed definitions for different activities. Some of them did prohibit the sale of food items. Some didn't. And, being in a county where we don't have as much definition of some of the other counties, that does put it in our lap for interpretation.
Thank you. Board members, any other comments, questions? Mr. Van Vactor, I think in your rebuttal you mentioned that other agricultural activities, 829, third-party sellers, or third parties selling to consumers have nothing to do with agriculture. I think that was the note I made of your comment. And yet this board on 2 occasions has allowed wedding venues, which seems to me have even less to do with agriculture. you'd like to respond or enlighten me, be glad to give you a minute or two.
Well, sir, I don't believe it's of any effect what the board has decided before relative to these wedding venues. That was its own issue. Whatever was decided there was decided there. I do think it's worth reiterating that when you're bringing, I believe there's a distinction here between what would even be considered a farmer's market. I don't recall, I haven't gotten the transcript yet. I recall some mention of people raising animals and bringing them there. I don't recall any testimony from anyone directly who said that they did that. And I may be mistaken in that regard. I do recall mention of that. But there is a big distinction between a farmer growing certain crops or raising livestock, taking it to a farmer's market and selling it. That provides a specified place where, as you said, farmers can come to sell something off-site. What we have here are people just bringing animals to sell them to the public, and this happens to be in an area that's zoned residential agricultural. I think we're almost going backwards in the way that we're applying this to make the other agricultural activity category fit what they're proposing to do, rather than them making their proposed use actually fit the ordinance, if that makes sense. It feels to me in some ways that we're straining to wrap up what they want to do in something that we're okay with, that's approved by the ordinance, rather than their proposed use actually fitting into the ordinance itself. And I hope I've answered your question, and I'll just quickly reiterate the point that if the approach is to stretch the meaning of this other agriculture-related activities to fit uses that are not permitted in a district, then what is the point of having those different categories? What is the point of having different zoning districts? It's taking the legs out from under the ordinance entirely, because you could make any activity fit this.
Thank you. It's only fair, Mr. Gillingwater, if you want to take a couple minutes.
I won't take 2 minutes, but I will say this. That I will reiterate that the board has the ability to interpret what that means. And if the city council didn't want to give you some discretion, they could have been more specific. If there's any doubt about what that means, benefit of the doubt goes to the property owner, and the board gets to interpret what this ordinance means. But again, ask your attorney for his legal opinion, not mine.
And I would like to make a comment here in the conditional use permit, which was granted. This is, for want of a better word, this conditional use is on a trial basis. That's the best phrase I can think of right now. It says initial approval for this thing is from July 13th to October 31st, 2021, and requires a new application. It's not just a renewal like generally. Somebody is granted a conditional use permit for whatever, for a term, the term's up, they pay their renewal fee and no complaints, it's renewed. That's generally almost always the way it works here. But this one requires a new application. So Ms. Smith is gonna have to start all over again, and we'll have another hearing. And if there have been abuses or problems or something, they will be addressed then. So I think there is quite an adequate safeguard built in. In addition, when the meeting started, I read this thing, which has quite a lot of conditions attached. And we've heard testimony from a very close neighbor that in the one instance that was held recently, that there, at least in her opinion, there was no great problem. That's just my comment. Board members, any other questions?
Yeah, I'd like to make a couple other comments. So in this document produced by the Indiana Department of Agriculture, it says, with more than 300 destinations in 2017, agritourism is a growing sector within Indiana agriculture. These destinations provide education and fun for families wanting to experience the farm and learn more about where their food comes from. It goes on to say agritourism activities are those that bring the general public to the farm for agricultural-based activities.
Board members, any other comments or questions to the various parties?
Well, I think I have a comment. I was not at the July meeting. I was out of town, but I did watch it on the YouTube channel or whatever. So I did see the whole meeting concerning this. But I think where I have a problem with when the board allowed it, and Rick, you read about the agritourism thing, and I also looked at, I just happened to copy the Bartholomew one, the same thing that you're looking at, because I don't know a lot about agricultural stuff, having not lived on a farm, blah, blah, blah. So I wanted to do some research. So I think the problem I had is when we talk about agritourism, they talk about things that are grown on that farm, and then you learn from things that were grown on that farm. Whereas this, as you mentioned, is people bringing other things in. So to me, it was more retail. And I think I would have classified it or put it under conditional use under retail, and that's what I had marked in the book. Like I said, I was not at the July meeting, so I didn't get to speak then. But that's what I classified it was. And so I was surprised when it did get passed for 829 under other agricultural, because I just didn't see that it fit there. So that you know, it's just my opinion of what, from reading and the research I did.
Thank you. Board members, any other comments or whatever, questions?
No, no questions, but I saw some things from both sides here. Some of it into, you know, the detail of the words, definition of words that are striking. You talk about retail, you talk about different things. Do make me think further than maybe what we had thought during that meeting. The other side of it is that there is an interpretation allowed, and this board is to look at that. New terms I've not heard, agritourism, multiple you know, ordinances, state codes, different things brought up. I think that really going to require some study on that to apply this, because it obviously needs to end up being fair to both sides.
Well, I have a question for our attorney. Section 11.76 says the Board of Zoning Appeals, that's page 127, may reverse, affirm, or modify the order. And under number 2 there, excuse me, it says the Board of Zoning Appeals should make a decision on any matter that is required here under section 11.16, either at the meeting at which the matter is first presented, which I would take that to be this meeting here, or at the conclusion of the hearing on the matter if it is continued. So if board members would like some time to think over what kind of a motion they'd like to make, would it it be appropriate to continue this, say, to our next regular meeting and make a decision then?
I think that's appropriate, as you could move to continue it to the start of that next meeting, and that'd be the first thing that's addressed. You could open the public hearing. If there's any additional comments from the board, you could address it then, and then close the public hearing, and then during the regular meeting, make the motion to affirm, reverse, or modify.
Okay, thank you. So board members, we have the option of either making a motion right now to reverse, affirm, or modify this order, or we can make a motion. I get the sense a couple of you are not so sure. We can make a motion to, like our attorney said, continue or table it until the start of our next meeting, which is September 13th, not that far. That's correct, right? 13th of
Yes.
September. Well, that's not that far in the future, and then make a motion then and vote on it. So, board members, what would you like to do?
I would make a motion that we continue this to the beginning of the next board meeting. I know me personally, that struck several things that I would like to do further research on.
We have a motion to table it till our next regular meeting. Do we have a second? I'll second it. Do we have a roll call vote?
Nancy Burkhart,
Yes.
Scott Baldwin,
Yes.
Rick Ferris,
Yes.
Mark Acosta.
Yes.
So we have just voted to table our actual decision until the beginning of our next regular meeting on September 13th, at which time we will possibly hear a little more if deemed appropriate, or we will just simply make a motion and vote on it. So that's what we have done. So I think that concludes our hearing. Take a motion to adjourn.
Move we adjourn.
Second, all in favor, say aye.
Aye.
Opposed, no. We are adjourned.
Thank you, folks.
Next week.